50 and 51, Kuzmich versus Murray Street, 5550 Murray Street, and West versus B.C.R.E. Counsel?
Good afternoon, Your Honors. Could I reserve 3 minutes for rebuttal?
You may, sir.
I want to begin with the text of the law. Actually, I'd better begin by finding my notes. Well, I'm going to begin with the text of the law anyway, which is...
Probably say it in your sleep, right, Pastor?
First time I'm nervous. The text is at page 4, I believe, of my main brief. Notwithstanding the provisions of any local law for the stabilization of rents in multiple dwellings, or the Emergency Tenant Protection Act of 1974, the rents of each dwelling unit in an eligible multiple dwelling shall be fully subject to control under such local law, unless exempt under such local law from control by reason of the cooperative or condominium status of the dwelling unit. Your Honors, it's extremely hard to make those words say, as my adversaries argue they say, that those multiple dwellings will be fully subject to control except for the huge majority of them that can be rented for $2,000 or more a month.
But counsel, it seems to me they have one pretty good argument, right? Which is when they put this luxury decontrol in place, they don't mention this statute. And I know this one wasn't in effect at the time that was enacted, but one, they could have gone back and changed that, or, when they enacted this, or two, there's a similar, I think it's 654 statute that also isn't mentioned in the luxury decontrol. So how do you address that argument?
Well, Your Honor correctly says this is not really an expressio unius exclusio alterius situation, because the alterius didn't exist when they expressed the unius. That
was on the tip of my tongue.
They could have gone back and amended it, and they didn't. But what you've got there is an inference from legislative inaction, which is about as weak a read as you can have for a statutory argument, because of course legislative inaction can mean everything or nothing. And to me, the most reasonable and the clearest reason they didn't go back and amend the former statute is they'd said it once, and they did not necessarily think they had to say it twice, even though maybe they did say it twice back in 1993 when they originally enacted the high rent decontrol. The fact is that the statute they did enact in 1995 I can never remember numbers, but it's G6, says it quite as clearly as it can be said. And I think it becomes clearer the more you read it. And I want to illustrate that by trying to look at ways it could have been written. The statute could have said, eligible dwelling units shall be fully subject to the provisions of any local law for the stabilization of rents. And I've just imagined one with no notwithstanding clause, just that simple sentence. Fully subject to the provisions of. There are statutes that say that. My adversaries quote some of them. If the statutes just said that, fully subject to the provisions of any local law for the stabilization of rents, they would have a strong verbal argument. And I would be standing here saying, don't fuss about the exact language because they couldn't have meant this, which is, I still think, not a bad argument. They could not have meant to eviscerate the very rent control they were enacting. But they would have a strong verbal argument. Problem is, it doesn't say that. It doesn't say fully subject to the provisions of. It says fully subject to control under such local law. And that makes my verbal argument much stronger, because I suggest if there is one thing subject to control doesn't mean, it's subject to decontrol. And now let's remove the myth that there's no notwithstanding. There is a notwithstanding clause. The notwithstanding clause. I haven't read it in...
Well, what about the argument that subject to control means govern as opposed to subject of rent control or rent stabilization.
I don't think you get there, Your Honor. I mean, the easy thing to say is subject to the provisions of, if that's what you mean. Subject to control under. I don't see how it can mean anything except subject to control of rents pursuant to the local law. Control in this context has to mean control of rents. It's not control of something else. The notwithstanding clause says, notwithstanding the provisions of any local law for the stabilization of rents in multiple dwellings, or the Emergency Tenant Protection Act of 1974. And of course, high rent decontrol is a provision of both those things. And how did those get, how could those not be, if I may use the strange verb that is sometimes used in Albany, how can those not be notwithstood by that notwithstanding clause? How can they not, and if the notwithstanding clause doesn't do that, what does it do? And that's a question we keep screaming, and my adversaries, I think, have not answered. They never tell us how this law would be any different if there were no notwithstanding clause in it. In their world, the notwithstanding clause is the Maytag repairman. It has absolutely nothing to do. It might as well not be there. And then, I'm not done with the text.
Let's say we agree that the text is not ambiguous, there's only one way to read it, as you suggest. Do we still have to look at the legislative history?
I don't mind. There is authority that says no matter how clear it is, go ahead and look at the legislative history. Fine. I'm all in with looking at the legislative history. In fact, I think I'll even skip over the co-op and condominium exception with just a passing remark. Why, if they put that one there, why didn't they mention the other exception? And now let me turn to the legislative history. I think to understand it, you have to begin with a perfectly obvious fact that everybody knew in 1995 the Assembly was friendly to rent control and the Senate was hostile to rent control. And that's very basic to everything that went on here. The Assembly, the pro-rent control House, passes the bill I've been reading aloud for the last few minutes. The Assembly has no reason to believe it means anything other than what it says. There's even a letter from the city reinforces the point. Page 7 of my brief, the letter says, dwelling units in the buildings receiving benefits under this program would be subject to rent stabilization during the benefit period, not to the provisions of the rent stabilization laws, to rent stabilization. And that's all the legislative history we've got in the Assembly. We've got the absolutely plain text of the bill and a sentence that reinforces it. The Senate passes the bill goes to the Senate, which is much less friendly to rent control. It goes particularly to Majority Leader Bruno, who doesn't like rent control, and he doesn't like the bill. He says he doesn't like it because it doesn't provide for high rent decontrol. And he says the bill isn't going to pass unless it's amended. And the newspapers quote him as saying that. And my adversaries say, you can't read that. That's too much legislative history. You're not allowed to look at the newspapers. Newspapers don't count. They're completely wrong. Newspapers do count in legislative history. Discussion in the public press is a totally appropriate way of understanding what people thought a law meant at the time the law was passed. What the public thinks matters. They're the bosses. They're the people the legislatures are working for. And we cite cases on that. It's in page 23 of I think it's our reply brief in Kuzmich in the footnote. And they don't cite anything that says you can't read newspapers. They just say, oh, that's newspapers.
Counsel, let me just skip ahead to the mayor's letter, because I'm not sure that I read it as inconsistent with the position you're taking anyway.
I don't either.
Because to me at least, it doesn't answer the question of when these things become subject to rent stabilization. That is, the letter says these properties will become subject to rent stabilization just as any other properties, but it doesn't say when that will happen.
I see your point, Judge.
Right?
Well, I hadn't thought of it. I think that's a good point, that the mayor's letter is, in a sense, true, although...
And there's a provision in subsection G that has a special mechanism for removing these properties. That is, if you put a special thing in 12-point type in the lease, they will come out.
Yes.
And isn't a way to read the mayor's letter to say, we want to make sure that that's not the only way you can get out of this. You can also get out by the normal ways of getting out once the exemptions, once the tax benefits are done.
I think that's true, Judge. I think the mayor's letter is consistent with that. I can't really stand here and tell you that I really think that's all the mayor and the majority leader were trying to say. I think they were trying to achieve high rent decontrol, but they were trying to achieve it in a statute that does not provide for it by putting it into the legislative history. And even the legislative history, as you point out, is a little ambiguous, but let's assume it's not
Let's say you have a
ambiguous.
situation where the Assembly, as you say, votes for a piece of legislation that they believe means rent stabilization is going to apply. And the Senate says, we would never vote for such a bill. We'll vote for the bill if it means luxury decontrol applies. That's the way we interpret it. What are we to make of that? If you have these
Well,
two
the
bodies that look
tiebreaker is the text, Your Honor. You read the statute is how you figure it out. And read it, and I love reading the statute. I'll read it again if you, well, I won't, but you get the idea.
But aren't we in a position then we're reversing the normal approach to the analysis here if we take that approach, Counselor? Aren't we saying, it seems your first argument is a plain language argument. The second argument is a legislative history argument. Generally, we don't get to legislative history unless there's ambiguity in the plain language. And then there's, of course, then we have to address the agencies, series of agencies, letters that have come up. You haven't gotten to those yet. But do we need to even weigh into the morass of legislative history? People have legitimate political differences about how these public policy questions are going to be resolved, and that's why we as a court always rely first and foremost on the language.
I'm absolutely think you can and should rely on the language here, and if you never glanced at the legislative history, this would be a pretty easy case.
The problem with legislative history here is because of the letters, say, between the mayor and the majority leader, you get into a discussion about what is authentic legislative history as opposed to inauthentic legislative history. I'm not sure I agree with you about newspaper articles one way or the other. More compelling to me is, what did the sponsors say? What were the committee reports from the legislative body? That kind of legislative history seems to me is relatively more authentic. But for the court to determine the authenticity of legislative history, it seems to me a long reach for us to be doing that when really we haven't even decided that the language itself is ambiguous.
Okay, well, I do think the language is unambiguous, and indeed, I think that's what Judge Edmeade, and if I'm remembering correctly, Judge Reed also thought. I do think it's unambiguous. I also think that if you do look at the legislative history, you should give considerable weight to the fact that Senator Bruno and Senator Libel first thought that the bill needed to be amended. And even if you don't read newspapers, you can read Mayor Giuliani's letter saying, you asked that the bill be amended. And I'm very eager to ask questions which I can never ask, like, what made you think it should be amended, Senator?
So we take it to the next phase then. What about the agency interpretations?
The agency interpretations, I just don't think they outweigh either the text of the bill or what went on, especially when you look at the context. The mayor's letter makes a commitment and says, don't worry, the city will interpret it this way. And then my light is on, but if I can just finish the answer to that?
Yes, please.
They say, and the agency does interpret it that way. The interpretation is to write in a whole new exception for high rent decontrol. It's not really interpretation at all. It's the text of the statute with another exception added. It's hard to call that interpretation. DHCR, I can't be quite that sharp about, but the fact is all they had was an ex parte presentation from the landlords. I'm not accusing anyone of doing anything bad. Of course, perfectly appropriate for the landlords to go to an agency and ask for it to be interpreted their way. But the agency wrote them a letter saying, look, this is as far as, this is what it means as far as we know. Don't take this to the bank. This is not an official interpretation. It's just a letter. I don't think it has that much weight.
Thank you, counsel. Counsel?
May it please the court, James McGuire for 50 Murray Street. I'm going to step out of my order a little bit just to answer a couple of questions here and respond to a couple of points by Mr. Smith. Senator Bruno did not say that the bill needs to be amended because it didn't provide for luxury decontrol. He emphatically did not say that. He said that he wanted to see it amended to ensure that the bill provide for the most recent updated versions of the rent stabilization codes. Because he may have had some uncertainty about it, does it mean that it didn't provide that?
Let's get to the plain language. I'm having great difficulty with your proposed interpretation because it seems to render meaningless, or at least superfluous, the whole notwithstanding language.
Okay, and I want to also respond to that too, because it does not, emphatically, our position does not render the notwithstanding provision meaningless. It gives it full meaning. Without the notwithstanding, there's existing provisions of law that say post-1974 construction and development are not subject to rent stabilization. So that's what this does. It gets rid of that. And I want to talk about the text too, but I want to talk about, I think we have a different understanding about what are the principal texts here. I think you look at 427G
Well, doesn't notwithstanding mean regardless of everything else? And so regardless of everything else means that these properties are subject to rent stabilization for the period of time set out in the paragraph, unless it's a co-op or a condo? I'm just not understanding your argument.
Well, okay, that's fine. It's a fair question, Judge Rivera.
I thought
and
so.
Okay. So we say fully subject, and we say it means subject to the burdens, and also to the benefits. My adversary puts a lot of weight on the word control, and he even says, so quoting a Cambridge Law Dictionary, that it means limits. But as we quoted, the Oxford English Dictionary, consonant with what I heard Judge Feynman saying before in our briefs below.
I'm not saying that that's my view.
No, I understand.
That's your argument.
Consonant, no, and I didn't mean to suggest that it was your view. I'm sorry, Judge. But the Oxford English Dictionary defines it as control, quote, the function or power of directing and regulating. So we're saying regulating.
Yeah, but high income rent is called deregulation, not regulation, right?
Deregulation is part of the entire scheme.
It's a compelling use of language that counsel makes when he says control doesn't mean decontrol.
I'm certainly not saying that there are no text-based arguments on behalf of the position that my adversary is making.
Counselor,
I do want to focus on the list of exceptions.
Let me just ask you,
Sure.
while we're on that subject, on the notwithstanding language, your adversary says that you don't answer how the law would be different without that clause. Can you answer that question? How would the law be different if you took the notwithstanding language out of that provision?
They wouldn't be subject to rent stabilization.
Then it would be subject to rent stabilization, or it wouldn't?
Without that, they wouldn't be subject to rent stabilization at all.
Because it's built after 74.
Yes.
Counsel,
But then
move to,
Okay, I'm sorry.
why don't you move to the exceptions?
Okay, but can I just give me a little background, with a minute of background to that, because I think it'll help?
Of course.
So, when the legislature enacted this program, they obviously hoped it was going to succeed, and a vibrant community was going to ensue. And it did succeed. It succeeded probably beyond their wildest expectations.
So the purpose is revitalization?
Yes, right. This ghost town. And they became
it is
so
possible that that's not the only purpose, correct?
No, of course it is. Of course it's not the only purpose. That was a principal purpose of the bill, though. And indeed, as the 50 Murray buildings show, the first rents it was so attractive that over many rents were over $5,000, over $4,000. And it's not true that all of them were. The record says 125,000 units created, and about 15,000 were ended up being stabilized because it was so successful that 15,000 were for initial rents. But here's the key point, right? So some of them, it's such an attractive place. 4,000, 5,000. In the decision of Judge Hagler mentioned, it's Henry 85 LLC Street. He ruled the same way as the appellate division in this case. It was a 3-bedroom duplex with 2 terraces, and the rent $6,800 a year. For all we know, there are penthouses down there being rented for over $10,000. Does it make any sense whatsoever to think that either house thought that people who were paying that kind of rent were deserving of the solicitude and the protections of the rent stabilization law?
But
No,
then why,
it makes,
Counsel,
it makes
why
no,
put that provision in at all? If it's just going to be, well, maybe these rents are going to be over the luxury threshold, why even put it in? I mean, they had an idea about putting that provision in, it seems fairly clear from the statute, that in exchange for this benefit, there was going to be some type of control over these apartments. And not just the ones that the landlords decided were going to come in under a certain level, because the controls apply to certain increases over time. And isn't it a fairer reading of that statute that that's what they intended?
Well,
and it wasn't going to leave it up to the landlord to charge $10,000 a unit so they could decontrol it?
why, well, okay. They certainly envisioned that these rents could be possible. As Senator Leichter thought that was exactly what was going to happen, right? And my point is, why would they think that somebody paying $6,000, $7,000 a year needs the protections? It doesn't make any sense. The legislature that 2 years earlier provided for luxury decontrol. But I do think that we all know you have to read individual statutes as part of the statutory scheme. It's an ancient and hoary canon of construction. And what happens is in 1993, we have this historic legislation that creates luxury decontrol. And the legislature says, whoa, wait a minute, we're going to have, everything's going to be subject to luxury decontrol except for three classes of buildings, right? The loft low ones, and then the two that are most critical here, 489 and the 421F, 421A buildings, right? And those are buildings that are not eligible for luxury decontrol because by virtue of the receipt of tax benefits, right? By virtue of the receipt of tax. 2 years later, after that historic and controversial bill, they enact this one. It's part of the same statutory scheme. And they leave that list of exceptions alone. You have to conclude that list of exceptions is exclusive. They leave it alone. Read the statutes together. And Judge, there's another, Judge.
But just to go back to that point,
okay.
One, perhaps they thought, as your adversary argues, that they already were exempting it under the language of the statute that they had passed. And I find it a very difficult argument, notwithstanding the notwithstanding clause, to get to the end of this where they carve out later on the condominium exception. Why bother to do that if you're correct? Why bother to carve out one of these exceptions?
Condominium provision had always been carved out. That was just background law.
No, but that's the point. It's already part of the law. Why choose one particular exception, which you say is embedded in this, and say, oh, we just want to repeat. We just want to emphasize, which is your argument, that we really, really mean that with respect to the condos and the co-ops, right? I think that's where Judge Garcia is going with his question.
And here's the answer to that, and I think it's dispositive. The language of the notwithstanding clause of 421G, 421A2F is absolutely identical to the one in 421G6. Identical provisions are treated disparately.
So,
the
but
respect
then,
that the court owes.
okay, assuming that that is correct, that those two notwithstanding clauses are identical, but then what do you do with this thereafter clause that's in subdivision 6? How does that make any sense?
Well, you just have you have to read them all together. Is the point? Is the point, Judge Feynman? Is that it's part of a statutory scheme, and I think you have to conclude the legislature knows its own enactments. That's a basic precept of construction. The legislature depends upon the courts understanding that when the legislature writes them and when the courts author them. They knew 2 years later, 1 year after luxury decontrol was greatly expanded by City Council pursuant to Local Law Number 4. They leave that alone.
But I don't
And so
understand.
my adversary's position is that, okay, well, maybe they just wanted to clarify in 1993. That can't be right.
Well, what I don't understand,
confused, then they would be intending to confuse in 1995
Excuse me.
when they didn't add it to the list of exceptions.
What I don't understand is, as I understand your argument, under your reading of the statute, certain exemptions to the rent regulation regime apply? For example, the one that is actually listed for condos and co-ops, and one that's not listed for buildings that were rehabilitated after the 1974, or whatever the date was. Yet other exceptions, like luxury deregulation, decontrol, don't apply. How do you make those distinctions?
They do, the luxury decontrol does apply because of, and then the most telling indication of that is because it's not on the list, the exclusive list of exceptions that the legislature created in 1993. The court has to deal with that. The court has to make sense of that.
So
And there's only one reasonable
that's the
conclusion.
nub of your argument. Without that,
No, that's not. The nub of my argument, it's a key part of my argument, but it's not all I've got. I've got the legislative history, and the legislative history is absolutely rock-crushing. This is not simply one house legislative history. If I may, I'll try to be as quick as I can.
I mean, we
Okay.
understand about the letters and who said what and all of that, but the fact of the matter is that the bill was not amended, was not changed, it did not clarify anything, as far as I understand, after this correspondence went on. So it seems to me that maybe they thought they had something they didn't have.
But the premise is wrong. The premise is wrong, Your Honor. Mr. Smith has been saying that Bruno said the legislation needs to be amended to provide for luxury decontrol. He did not say that. He said it needs to be amended, in effect, to make certain that it does.
What is
And
the-
you
Well,
can
but
make
it
it
wasn't.
certain. You
But
can
it
make
wasn't.
Well, legislative history is a way of doing it. And
What
it's-
is the,
and it's-
what is the
and the-
rock-crushing part of the Assembly legislative history that supports your position?
Well, the rock-crushing part of it is on this incredibly important, Maverick says the Assembly is in favor of the tenant protections, and the Senate adverse to it. Not a single Republican vote in the Assembly against it. Not a single vote. There is ample opportunity for the Assembly to fill that bill jacket, for tenants groups to fill that bill jacket, as they often do with their positions. Silence. Not a word on this extraordinarily controversial subject. This is one House legislative history?
What about the supporters?
That's telling legislative, that's telling support.
What
don't
about the
think rocks
supporters
get-
memorandum?
Excuse me?
What about the memorandum in support of the bill?
Which, right, look.
That doesn't say anything?
It does, but I don't, but it's not, it's certainly not, it doesn't address the only legislative history that's squarely on the point before the court, which is whether or not luxury decontrol is applied, is provided in the Senate, and it's unequivocal, it's on the floor debate, it's the mayor stating his position, it's Franz Leichter agreeing with it.
Since when is the mayor a part of the legislature?
He's part of the city was part of the drafters, and this court has recognized that drafters of it's part of the legislative history. But it
But
doesn't.
his counsel said something differently earlier on.
No, he doesn't. No, he
His own
doesn't.
official says it's subject to rent stabilization.
Well,
His own
listen,
official says
newspaper
these
stuff, I don't
properties
know,
will be subject to rent stabilization.
I don't know if they were quoted correctly or not, but the point is, it's not just the mayor, Judge Stein, it's not just the mayor. It's the Senator Bruno's there's a letter in the bill jacket from Senator Bruno says this comports to our own understanding. Franz Leichter is the only senator who disagrees.
Understanding
Marty Connor.
or alternative hope?
Excuse me?
Understanding or alternative hope?
He's understanding that they're going to be over the threshold and they're going to be decontrolled.
As Judge Stein pointed out, he's not a senator. He was not a senator.
Franz
to vote on
Leichter
it.
was. Franz Leichter was.
I thought you were talking about the
No, I'm talking
mayor
about
at the
Franz
time.
Leichter. He was a senator. He was the only one who expressed, nobody contradicted him. Senator Connor, the sponsor of it, he doesn't contradict him. He never sends any member. In the bill jacket includes a letter from Marty Connor's counsel, the Senate Majority Counsel. He says nothing about the subject. This incredibly important subject, he says nothing. He doesn't disagree. Nobody on the floor disagrees. To rule in favor of my adversary, you have to say that legitimate legislative history in the Senate that's squarely on point with, at best, in a bill that's got ambiguities. He's got some points, my adversary. But you have to say, even though you've said legislative history is always relevant, even when the text is clear, you've got to say, disregard that. And these people making 7, 8, 9... I'm sorry.
If the legislative history is completely at odds with the text, and the only sensical reading of the text, which do we choose between?
The legislative history is completely consonant with the text.
No, that was not my question. I'm giving you a hypothetical.
Okay.
If the legislative history is completely at odds with the text, and the only sensical reading of
Go with
the
the text. You go with the text.
Thank you.
Yeah, absolutely.
Counsel? I mean, Judge?
Yeah. On the text, all right, I'm not asking about legislative history. I'm still not sure I understand your answer. In subdivision 6, the first part corresponds to the same language that you find in 421A. But there's this sentence, thereafter such rent shall continue to be subject to such control, except that, and it goes on and explains, and it talks about how you decontrol. And, you know, the sentence goes on for quite a bit.
Right.
Why would they be talking about decontrol if it's not controlled in the first place?
Because some will be controlled, Judge. Some are controlled. A significant percentage of them were controlled. And these are instructions, the ones with first rents that were under the threshold. And so you need to have a rule for what happens. And they, at the time it's drafted, they don't know how successful it's going to be. It could be that the vast preponderance are going to be under 2,000. They don't know.
So maybe I'm not understanding your position completely then. I thought your position was not only is it subject to luxury decontrol, but it's really not subject to any control.
No. That we have so consistently said, and our adversary seems to be imputing to us a position we've never taken.
Okay.
We've always said, all the legislative, the Senate was consistent, always. It was subject to rent stabilization, but it was also subject to decontrol. Senator Bruno would have preferred that there was no stabilization at all. He lost the battle. He couldn't get that. He couldn't, right. He couldn't get all he wanted, but he got something consistent with what they did in 1993. They weren't doing a backstroke on what they did in Bruno and the Senate wasn't doing a backstroke, and the silence in the Assembly confirms that. Thank you, Your Honor.
Thank you, Counsel. Counsel?
Good afternoon, Your Honors. I'm Magda Cruz, co-counsel for the respondent 50 Murray acquisition in the Kuzmich appeal and counsel for the respondent B.C.R.E. in the West appeal. B.C.R.E. supports and joins in the arguments made by my colleague James McGuire in the Kuzmich appeal concerning the construction of the real property tax law 421G and the rent stabilization law 26504, not precluding high rent vacancy deregulation in these lower Manhattan buildings. And I'd like to emphasize that the scope of the 421G program was very, very targeted. It was to address almost, I would say, an economic crisis that was happening in the 90s at the time that this legislation was proposed by the mayor of the city of New York under the Lower Manhattan Revitalization Plan. This statute, 421G, is unlike 421A, J51. It is a very, very targeted piece of legislation, and we cannot ignore that history because it is very telling why, in fact, it was not included in the list of exclusions in the rent stabilization law 26504. It was not included, of course, when it could have been included. Maybe.
But if we disagree with some of the arguments about the statutory language and any ambiguity, or if we feel that the statutory language is clear, then why would the legislature need to go back and amend the rent control law, in addition to what it may have thought it clearly said
Correct.
in 421G in the first place?
Yes. My answer to that, Your Honor, is I agree. It is clear. The notwithstanding clause is clear. It was clear when 421A was enacted to show that it would be subject to the entirety of the rent stabilization law.
But isn't there a different situation when a new law such as the rent stabilization law, I mean, that was a pretty major piece of legislation, right? That comes along after the language in 421A.
Yes.
Right?
Yes.
So then it seems to me that there might be a reason to say, even though we're enacting this law now, we want to say that what came before it is not swept
Right.
swept within, right?
That's a logical assumption of how the legislature would have addressed the 421A and J51 and loft-law exclusions. But when identical notwithstanding language is enacted as part of 421G 2 years later, and that 421G is not included in that list of exceptions, the presumption, and I submit to you, is that, in fact, as the Senate debate shows, 421G was not intended to be excluded from luxury deregulation. And it is, I think, because of the genesis of that law, the fact that it was a targeted, specialized piece of legislation, that it was meant to revitalize a situation in Lower Manhattan that was critical, the financial center of this country.
I make the point to you also, could there not be more than one purpose?
Yes, Your
Or
Honor.
could seek to revitalize and also to provide for affordable housing?
Yes, Your Honor.
Or, or put it under the umbrella of rent stabilization.
Judge, can I just ask one question? Just to clear up in my own mind, the bond purchasers, the prospectus to the bond purchasers, doesn't it say there that 421G also, the same 421G rules apply for the duration of the tax benefits that you get as a result of the bond purchase?
Yes, yes.
And what's the effect of that?
Well, the presumption is that rent stabilization is a scheme of regulation that includes
Let me ask you this,
luxury deregulation under appropriate conditions.
Let me ask you this. Do we fall back on a plain reading then of 421G6?
You can, Your Honor. Absolutely, you can fall
And
back,
can
but
your
you must
argument-
read it in conjunction with the rent stabilization law 26504.
All right, so can your argument be successful without a legislative history component?
I submit it can, but the legislative history component absolutely reinforces it. And, Your Honor, my light is on, but I would like to address Judge Rivera's question about an alternative goal of the law. And yes, Your Honor, absolutely. It could have also been intended to advance affordable housing in that area of the city. But it was, in fact, addressed by reason of the fact that the housing has to be subject to rent stabilization, but the entirety of rent stabilization, Your Honor. And in the case of 90 West, of the 410 apartments that were created, 140 were below the threshold. Those were not luxury deregulated.
Isn't your textual argument at the end of the day that the legislature, if it really wants to recognize an exemption or exclusion, has to state it expressly? It can't use notwithstanding clauses. It strikes me that if we adopted your reasoning, this would put in question other pieces of legislation where the legislatures have used that clause.
Yes, Your Honor. However, I don't think it would necessarily put a cloud over that kind of legislation, because the rent stabilization law, luxury deregulation provision, created the list, exclusive list of the kinds of housing that was benefited by certain tax programs and the loft law that would not enjoy luxury deregulation for purposes of that particular set of apartments. Every single tax benefit has a goal. In this case, the goal was revitalization of Lower Manhattan, preserving rent stabilization.
But
all
revitalization, of
the-
course, could also mean having affordable housing where you have a thriving community of tenants who live in that affordable housing.
Yes, Your
They're
Honor.
not mutually
They're
exclusive.
not mutually exclusive, but it.
You don't need
can't-
only the wealthy downtown.
That's correct, but that is not what, in fact, occurred, because, as I said, 140 apartments in my client's building fell below the threshold, less than $2,000 a month, and those apartments remained subject to rent stabilization, but those that met the criteria of luxury deregulation, which is part of rent stabilization, were entitled to enjoy those benefits. Thank you for your indulgence, Your Honor.
Thank you, counsel. Counsel? Counsel, what do you make of the silence on the part of the Assembly?
I've never heard that there's any significance to silence by the House that has already passed the bill. It is not the burden on the Assembly. Having passed the bill in perfectly plain language and with perfectly plain legislative history consistent with the language, the Assembly is supposed to monitor the Senate debate, find out what Mayor Giuliani wrote to Senator Bruno, and lodge some sort of protest, fill up the bill jacket, as Mr. McGuire said, with protests against this outrage. That's not the way it works.
What about what is there, which is Senator Leichter's letter?
Yes, Senator Leichter was had, I must say, Your Honor. Senator Leichter believed that the legislative history magic worked to overcome the text. I think he was wrong. I think this court could do a useful service, among other things, by reminding legislators who sometimes may be prone to believe this even when they're opposed to the particular bill in question, you can't write law just by writing legislative history. You've got to write law. I think Senator Leichter, along with Senator Bruno and Senator Leibel and perhaps some others, forgot that. Mr. McGuire did try to answer, I think when Judge Stein asked the question, how would this be different without the notwithstanding clause? But I don't think his answer works. Let me read it for a minute without the notwithstanding clause. The rents of each dwelling unit in an eligible multiple dwelling shall be fully subject to control under such local law, meaning any local law for the stabilization of rents. He says that means it's not subject to stabilization without the notwithstanding clause? I don't think so. And the notwithstanding clause does not. If there's a problem there, the notwithstanding clause is not the way you would pick to remedy it. Both Mr. McGuire and Ms. Cruz talk about the purpose of 421G, which is indeed to produce this wonderful revitalization and 24-hour community. But the purpose of subdivision 6, the purpose of 421G6 is one purpose and one purpose only, to make the building subject to rent stabilization. And finally, Mr. McGuire makes come on, you don't want to do rent control for the rich argument. What those arguments always forget is that if the law had been followed, if the rents were where they should be, the people in those buildings would be considerably less wealthy. You'd have more middle-class people in the buildings because the rents would be lower, and that's the whole point. Yes, rent control does sometimes benefit the rich. In Thornton v. Barron, it benefited Cyndi Lauper. But that wasn't because the court imputed to the legislature a love for the Cyndi Laupers of the world. It was because the rent control laws cannot be enforced without doing that, and that's how you get a rent control regime that permits less affluent people to live in these buildings. At least that is the policy behind the law.
Thank you, counsel.
I like Cyndi Lauper. I just want to let everybody know.
I did not mean anything personal about Cyndi Lauper.
Thank you.
We all just want to have fun, Your Honor.
Good.
Thank you, Your Honor.